can you bring a personal injury claim if you're blamed for an accident in the state of Nevada? Well, the short answer is it depends. Nevada is what's called a modified comparative fault state, and so what that means is you can seek to recover damages in a personal injury case as long as you're not more than 50% at fault. If you are more than 50% at fault, then you get nothing. So, for example, let's say a person is driving and runs a red light, and another person is going through the intersection and gets hit, but the person going through the intersection that got hit is speeding. So the two go to court, and the judge or the jury says, all right, the person that ran the red light, 75% at fault. The person that was speeding, 25% at fault. So if I'm the speeding car, I can still recover because 25% is not more than 50%. So what'll happen is if my recovery is $100,000, well, the recovery is going to be reduced by the percentage I'm at fault. So it's 25% of the recovery would go away. So instead of collecting 100,000, I'd only be collecting 75,000. Lawyer math. But let's talk about the guy that ran the red light. That person was found to be 75% at fault. Well, 75% is more than 50%, so that person recovers zero. Now, in some other states, like California, they use something called pure comparative fault, which means both sides could recover. The person that was 75% at fault would still recover, but his recovery would be reduced by 75%. So if his damages were 100,000, they would be reduced down to 25,000. So if you're in Nevada and you've got questions about this comparative fault, or if you can bring a lawsuit, even if you're being blamed for the accident, please feel free to give me a call or drop me an email.